for 2024. Call to order. Please stand and salute the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
In accordance with the Open Public Meetings Act, it is hereby announced and shall be entered into the minutes of this meeting that adequate notice of this meeting has been provided by the following: posted on the bulletin board of the office of the township clerk, posted on the bulletin boards within the municipal complex, printed in the Home News Tribune and Cranberry Press on December 29, 2023, posted on the Monroe Township website, and sent to those individuals who have requested personal notice. Please take roll.
Mr. Rothman,
Here.
Ms. Brodsky. Here. Mr. Patel.
Here.
Ms. Damiani. Mr. Slavacek.
Here.
Mr. Weiner.
Here.
Dr. Kenzie. Councilman Van Zora.
Here.
Mayor's Representative, Mr. Patel. Chairman Gaffrey.
Here. Okay, Laura circulated the minutes to everybody, and hope you have had a chance to review. Is there a motion to accept the minutes?
So moved.
Is there a second?
Second.
Okay, any discussion on the minutes? Okay, all in favor of accepting the minutes?
Aye.
Aye. All opposed? Any abstentions?
Extension.
Okay, minutes are accepted. Okay, this evening we just have one application. It's PB 1262-24, Green Vest LLC. Ms. Johnson.
Good evening. My name is Jen Johnson. I am from the law firm Flaster Greenberg. I'm here tonight representing my client, Greenvest LLC. We are here tonight for a minor subdivision, which in actuality is a lot line adjustment. My client, Greenvest, I have a representative from Greenvest here, and they own a large parcel of land next to several smaller parcels, but specifically two smaller residential parcels, and they would like to deed over a small sliver of property from the large parcel to each of these two residential properties because of existing encroachments on the land that have been there for a number of years. Greenvest just recently purchased the property, and they now would like to, they have already deeded the entire property, a conservation easement in perpetuity, but for these small slivers, and they would like to carry on unencumbered by these encroachments. So that's why we're here tonight. I have with me a representative, Brian Kramer. Would you like to swear him in?
Yes. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for our record.
Brian Kramer, CRAMER. I'm with Greenvest LLC. I'm a vice president here. And my office is 35A Kennedy Road in Tranquility, New Jersey.
Proceed, Council.
Thank you. As I said, the larger parcel is a little over 39 acres. The larger parcel has no improvements on it and will remain a conservation easement in perpetuity. The two residential properties to which we are looking to adjust the lot line to include a little bit more coverage to them, each has an accessory structure on it, which is why they're encroaching onto Greenvest's land, and we're looking to move the lot line. Nothing is changing. These are all existing, for a long time, pre-existing nonconformities, and we're not proposing any changes. We're not proposing anything new on any of the properties. Everything is as is. It is simply just looking to correct a lot line so everything is in conformity.
One thing I'd like to add too, there is, the entirety of the 39-acre parcel has not been conserved, less the slivers we're talking about conveying over, and there's an existing access easement through the middle that has not been conserved.
Correct. Thank you. And there are a few pre-existing nonconformities on those other parcels, like I said. We have those owners' consent to be here tonight to do this lot line adjustment. If any waivers or variances are needed for those, we graciously ask the board for those, and we can spell out the reasons why. But in terms of the subject parcel, there's no variances needed. Brian, can you please tell a little bit about GreenVest, who they are, what you do, what they do?
Yes. So GreenVest, we're a habitat conservation company. All we do is purchase properties for the sole purpose of habitat conservation or wetland mitigation, riparian zone mitigation. Some may be familiar with it. This property was wetland mitigation for one of our clients. We purchased it primarily to preserve it. We did do some minor restoration enhancement activities, basically tree planting on the property. So that's been completed, and the entire property, less the easement and these areas that we're proposing to adjust on the lot lines, has been conserved with a standard NJDEP conservation easement.
We have the review letters from your professionals, and there are a few typos and omissions on our plan that were pointed out. And of course, we agree to revise all of those, and that will all be, of course, a condition of any approval we were to get tonight. Would you like us to go through the review letters, or did you want to ask questions? How do you like to do this?
Mark, do you have any questions or?
Sure, I'll jump right into the review letter. My review letter is dated November 11th, 2024. And just right off the bat, I'll ask if you're agreeable to all the comments, and if not, which comments, and we can discuss that.
We are agreeable to almost all of the comments. We would request a waiver of G, any concrete curb or sidewalk improvements, since we're not proposing any improvements anywhere, everything's staying as is. And I believe we already provided the conservation easement. I mean, we can do that again. And we have, yeah, the county approval or exemption, that's fine. That is it.
Okay. So with regard to G, it's requires installation of curb and sidewalk improvements. As the applicant indicated, they're not proposing any construction on this site. I think I think a waiver would be in order for that. We also have a contribution towards the improvements of curb and sidewalk. I would say a waiver would apply to that as well. Again, there's no construction on here. We would typically take the contribution if they were constructing something and not installing the curb and sidewalk, but in this case, they're putting it into a conservation easement. So I would say the waiver would be in order for that. And just if you can explain a little more, what you do again as far as a conservation easement, like you're essentially buying land and you're just going to preserve it. So
we did preserve.
how does that work?
A client of ours received a permit to impact wetlands and riparian zone and other areas of the watershed. So they hired us to find parcels that what DEP would accept as mitigation. So if you fill an acre of wetlands here, you have to give them back wetlands somewhere else in the same watershed. So this was one of 3 tracts of land in Middlesex County that we purchased for this client to do mitigation. So most of it's really good forest habitat. So most of it was preserved. There was one small 2 or 3 acre area that was devoid of trees. It was probably an old field, had a lot of invasive vegetative species in there. We got rid of the invasive species and planted trees in that area. So the whole property, other than what we talked about, has been conserved under an easement's been recorded.
Thank you. Thank you for, explaining that a little further. Appreciate it. Chairman, I have nothing further.
Thank you. Does our planner have anything to add?
No, all previous comments have been satisfied.
Okay, thank you. I'll open it to the board. Any questions?
I have a question.
Sure.
Good evening, how you doing? So you're gonna give some land to the properties adjacent to you?
Correct.
And the properties that are adjacent to you, are they also conservation, or are they're like separate,
They're existing single-family residential. And we specifically, when we did my conservation plan for my property, I excluded these areas and didn't put a deed restriction on because we knew we were going to convey them to these owners eventually, so.
What's the size of the property that they have and how will your contribution change that?
Those exact,
I don't need it.
well, the subject lot is a little over 39 acres. Lot 605, we are proposing to deed 8,800 feet, and lot 602, we're looking to deed over 10,600 feet. But the existing lots themselves, I don't know if I have that.
Might be in the planner's letter, actually.
Oh, it would be on the zoning chart.
What I'm getting at, the real question is, by you giving them more land, is that gonna change their ability to develop further beyond I understand there's existing structures on each property, but will your, exchange of property allow each of those owners to theoretically build something bigger or different?
Well, no, I can see here, 602 is 1.15 acre, and 605 is 0.69 of an acre. And we are changing, no, it's,
And I-
602 is 0.9, and we're making it 1.15, and 6.05 is currently 0.69, and we would be turning it into 0.89.
Right.
It is still existing non-conforming.
It's-
So no, the answer is no.
Still an undersized lot,
Right.
even with the,
It-
I see our engineer nodding in agreement also. Okay.
Right, I
So
just
didn't
threw a
wanna-
lot of numbers out there, but the answer is no, right?
It's a little hard to just grasp from looking at the pictures and everything, and I wanted to make sure that by you doing what you're doing, we're not gonna have like major construction on the adjoining lots, not we're worried about yours. So,
Understood.
you know, but I think that's pretty clearly understood that's not the case.
and all developable area that there was some developable area outside of wetlands and transition areas on the larger lot have been conserved, so there's no development that will
No,
ever be done.
thank you. Thank you very much.
Council, you have any other witnesses?
I don't.
Okay, anybody? Any other questions, or does anybody else wish to be heard on this?
How many of you are? Yeah, I have to swear you in, so it's on the record. Do you swear?
What's
to tell
that?
the
I
truth,
can't hear
the
you,
whole
sir.
truth, and nothing but the truth, so
I
help
can't
God?
hear you.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, we state your full name and spell your last name for us.
My full name is Edward John Kurcheski, and the last name is spelled Kurczki.
Okay, thank you.
Okay, you can proceed.
You want to read your statement?
Hello, and thank you for giving me the
Hey.
opportunity to read my statement. I'm Edward Kurcheski, and I own the farm at 16 Federal Road in partnership with my brother, Sergeant John Kurcheski, a retired 33-year veteran of the Monroe Township Police Department. We own the historic Bailey Davidson Cranberry Farm on the opposite side of the tracks since 1984. I am a disabled veteran, 3-time cancer survivor, and have been a tree farmer here with my brother for the last 40 years. We have historic access and water rights through 3 of the properties impacted by this application. We object to the approval of this application at this time. We have a 10-foot historic access easement and water rights from 1908 as referenced in deed book 425, page 370 on these properties. Both Green Vest and the owners of 81 Hoffman Road had a responsibility to keep the portion of the easement to the northwest of the railroad tracks free and clear. Both have ignored my written requests to remove obstructions and respect my historic rights. Greenvest has gone even further by obstructing the access lane with a gate last summer. These property owners, who are both now clearly working together on this subdivision application, continue to ignore and deny my rights. Additionally, regarding the setup of a conservation zone in this area, I would like to directly ask this applicant, Greenvest, and the Township Environmental Planning and Zoning Board what they knew and when about this project. I have a deed in my hand filed by this applicant, and a part of this application packet before the board, Book 18282, page 1651, named Permanent Access Easement. I would like to point your attention to page 10 of 10 of that deed. It includes a site mark on the top right corner with my property marked Cranberry Bog, clearly within its bounds. Should I add, coincidentally, at the same timing when several issues began to crop up against my farm in 2020 by multiple parties, including the township and Conrail. Is this project tied to future plans that I seem to be the only one not aware of? Adding insult to injury, on Thursday, March 2nd, 2023, Brian Kramer, the VP of Greenvest, met with my son at the farm to discuss these access rights and had the nerve to hand him 3 more surveys with my property and the mitigation site mark. That's a total of 4 separate surveys where my property is in Greenvest project mitigation site mark. He additionally said in the near future they would be looking for more land. I would like to ask how and with whom did Greenvest determine the mitigation site bounds for the Hoffman Road wetland and riparian zone mitigation bank? Why am I only finding out about this mitigation bank now by reviewing this application before the board, even though it appears that this applicant has made assumptions about its bounds, which include my property that I still own? In light of these facts, in my interest to leverage my historic water and access rights on these properties, I ask this board to delay the approval of this application. Further, I would ask that an inquiry as to how all of this could have happened without my knowledge or a direct involvement could have occurred.
Thank you.
That's it.
Council, do you have any response to that?
Our only response is there is an easement clearly marked, and that has not been part of the conservation easement. And
And
Go ahead.
I will add to that, I met with Mr. Kaczewski's son. We did walk the old roadway that is the subject to the easement. The old easement didn't even describe an easement, it just said access. And we actually went a step further and described that access easement, did meets and bounds, and filed an easement. There's also an existing easement, I think it's on lot, it shows on our survey lot 6.05.
right.
That's 81 Hoffman Road. We don't own that property. There is an easement on that property. So it's our opinion that we are providing the access that Mr. Krajewski legally has.
Any questions, comments from the board or the professionals?
My only question would be to our engineer and planner. Were you aware of these issues coming into tonight's meeting?
Mr. Chairman, I'm not sure what the issue is. The plans clearly show the access easement. The applicant has indicated that it's clear, or you walked it.
And I should add that it's
So-
not our requirement. 'Cause
Was
it's
a
not
copy of that deed provided to this board, that easement deed?
the deed that, the easement that, the recent one that was recorded. I'm not sure if Mr. Krajewski's deed that's dated back. Double check that one.
So other than the access easement, I mean, the resident indicated something about water rights. I'm not sure where that is or what that has to do with this property, or if there's a separate easement for that. I don't know if the resident has a copy of that easement or can elaborate as to what that is, or unless the applicant knows what he's referring to about water rights.
Yeah, what the engineer is asking is, do you have a copy of the easement that you referred to in your statement?
Yeah, we have copies of everything from the 1800s on a deeded right-of-way for access to our farm. We have all that information. And now they want to take the, where we come out to Hoffman Road. And it's all identified on the paperwork. We can provide anything that you need.
Have you provided that to the applicant
They
before
have it,
tonight?
I'm sure. Sure they have it, because it's been deeded, it's a deeded access road for the operation that was back there. To get access to the Cranberry Farm. And they put a gate up and stopped us from accessing our property maybe 2 years ago on the railroad crossing. There's a deeded railroad crossing, and it's identified in the paperwork. A railroad crossing that's been upkept since the 1800s when it was put in. It was replaced 3 or 4 different times, and we were using it constantly until they came in and they blocked our access. They dumped garbage and, well, they dumped dirt on it, and then we couldn't get access to the property.
Does that it still exist, or is that been?
Yeah, it's still there.
There's,
We've been trying to get access to it, and we have no cooperation from the landowner. And now they want to go the last couple of 100 feet coming up to Hoffman Road, because you can see it on the maps. It's a gentle circle coming up. Now they want to go over behind the house and then come back up through there, which is it's gonna hamper our access to our property if we ever get that road cleaned up again. Right now, we can't use it for nothing. And then they put a gate in there to hinder our access on top of it all, which we don't think is right. That property, we've owned it since 1984. We've run it as a Christmas, we run it as trees, the whole 9 yards with logs, and we sell wood. We try to grow some trees and do that, and we like the access. We're not trying to hurt nobody. We just want to have our farm access left there and to continued existing usage of the farm.
I'd like to respond just about the gate. It's not even locked. It's to keep ATV use because ATVs up and down the railroad tracks are on our property. So that was the only reason the gate was put up, not to curtail Mr. Krzyzewski's access. The piles of dirt, I'm not sure where you're talking about. They're not on our property. That roadway is clear all the way up through there. It was always
Talking
clear.
to the mic.
There may be some-
Sorry, can't hear you. Can you talk into the
Oh,
mic?
sorry.
We can hear you.
Wait a
Okay,
minute, hold it.
you're not under oath.
Unless he's sworn in, he can't.
All right, I'll start over. The gate that was put in there was to not let ATVs on our property that were using the old access road there. It's not locked. It wasn't put up to curtail Mr. Krzyzewski's access. The roadway on the property that Greenvest owned is free and clear. There may be some tree limbs on it. It is not our responsibility to maintain that road. It's our responsibility to give access, which we're doing. I'm not sure where the piles of dirt are that you're referencing. They're not on our property. They could be on lot 6.05, I guess. Again, that's property that we don't own. The easement, legal access easements are there. So it's my opinion that access is being provided.
Just a question, Mr. Krzyzewski. When you received notice of this application, did you voice your concern to the township?
Was our concern with the township?
Did you voice your concern? Did you raise your concerns?
Yeah, we did. And I have the responses from the township, and that's what we're doing here.
Well,
Everything doesn't seem to be going in the right direction.
okay,
They're
who did,
trying to go around the houses now, take away our access the last 150 feet. That's been deeded, that road's been deeded, that access road has been deeded since the 1800s. Since the 1800s, it's been utilized, and now all of a sudden, they want to go around the back of these houses and come up the other side, and then take away our last 150
I
feet.
understand that, but my question really is, when you received notice of this application that we're here for tonight,
Yeah,
did
that's what we're
you
doing here.
contact the
We got-
township?
We had requests from the township,
And then
and we're addressing it right now.
did you raise your concern prior to tonight
Yeah, we've spoken to people numerous times,
in the township?
right?
Do you have,
We've spoken with many people. In fact, that we were in contact with Ron Appleby over years ago. To
okay.
maintain the opening, and it was maintained.
But please understand, sir, we're here for a noticed application. And it's an issue which is really, to us, something that we hadn't received notice of as a board. And my question is, who did you contact with the town? Do you have that contact in writing?
Before you speak up,
Swear me in if
yeah,
you'd like.
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your full name and spell your last name, please.
My name's Christopher Krzyzewski, Kurczeszki, and I'm Edward Krzyzewski's son.
Okay, now you need the mic.
So the property that's being changed here is part of the application where the historic right-of-way goes through. We have been negotiating and litigating with the town over several issues on my father's property for years. The township is well aware that we've been having challenges with access and other things, and we even asked for support from the access. I directly supported my father to do that, and we were ignored, including additional letters, which I have, and I'll be happy to produce copies of, where we have been trying to resolve issues on this. What's more important to me here is why does this applicant have a site mark on multiple deeds that our property is in? And what does that say about future plans and people's involvement here and what we don't know? I get that the application is about this subdivision and this property, but why is this applicant making assumptions about our property in the future for a mitigation bank? I have 3 surveys that he handed me here that our property is clearly within the site mark on. What is going on here with this applicant and why are they making assumptions that our property is part of this mitigation bank?
There is no, your project is not part of this. When I met with you, we discussed potentially adding your property to this. We never came to legal agreements on that, so we never added it.
In 2020, these surveys were produced, and on the top right corner, does it not say Cranberry Bog clearly within the site mark on that top right corner of your prepared deeds? There's 3 you handed me. That's our property that's in that
I
site
can't
mark.
really see.
This is a survey that shows the access.
The top
This isn't
right
a-
corner.
this isn't a
The top
deed.
right corner. It's in the deed in the application.
They're talking about the regional location map.
There's a permanent access easement application deed in this application packet that our property is in the site.
Your property's not in it.
Yes, it is.
That's a location map that shows the location of our property in the vicinity of this area of the
It says
township.
site, there's a circle, and our cranberry bog is in it. Okay, that's the mitigation site.
But that's not part of the applications.
Yes, it is. It's in this application. It's for this. Back to this application.
Chairman, I have kind of a fundamental question for either council or experts. If someone were to have an easement on a property, first of all, when someone conveys property, they can only convey whatever interest they have in that property. So if one was to convey interest from the applicant to the party next to them, the easements and whatever restrictions with that property go with it, do it not? So the only difference being that instead of the easements being held against the applicant, they would continue to be in existence, but just against the other property owner. It should not change any rights that Mr. Krzyzewski should have. He should still have the same
That is
rights
correct.
that he's always had. Unless I'm missing something, and I'll leave it to my experts to tell me otherwise, but I don't see anything in the application that is asking for doing away with easements or taking
can't-
away
yeah, we
something
can't do that.
from this gentleman, I would think he would have the same rights. Maybe instead of the rights going against these people, it goes against the other people. And if there's a dispute as to them not properly allowing him to assert his rights, then he certainly has legal remedies that he could pursue to force that. And I don't, I'm not going to say I know enough to say who's right or wrong, but you certainly, if you have an easement, you have an easement.
Yeah, so let me ask you
But I
something.
don't think that changes what they're asking to do
Let's
here.
calm down, back down at this point. If you want us to pursue legal, we've been pursuing plenty of legal options over the years, and it's been very difficult. No one wants to take on City Hall. There's a plan here for a mitigation bank. Our property clearly seems to be a part of it. Someone's not being transparent. That's my position on this. Go ahead and approve this. This is perfectly fine, but we will continue to pursue legal options.
Let me say something.
Calm down, please.
And
This is
I'm
it.
not
We
I'm
kind
not
of
trying
summed
to
it
say
up.
it in a way like,
Chairman?
but I don't know that this is something that's really affected that.
Mr. Weiner?
Yeah, I have a question for the applicant to clarify for the record, as well as commentary regarding, the issues raised by the gentleman from the public. I'll start in the reverse. Is I don't want to speak for one of the other board members, but I think I have a grasp of what the issue is here, and what's trying to be expressed is the planning board, as a board, we only have a certain legal amount of authority of what's called jurisdiction. Enforcement of other issues is not something that the board can do. There's no power. So I think that's what I was trying to gather, what Mr. Councilman Vanzora was trying to say, not in a antagonistic way of, if you have rights, go get them. It's this board doesn't have enforcement rights. We can't say, hey, this person or that person, you're doing something wrong. We don't have the authority legally to do enforcement actions. And I think that's where he was coming from, to say this may not be the proper forum, but under all means, if you feel you may have rights and remedies available to you, no one is telling you you shouldn't consider pursuing them. I think that's kind of where that went. It wasn't meant to be in any type of antagonistic way. It was just, even if it was obvious and 100% what you're saying and the board hypothetically agreed with you, don't have the power to do that. That's not what the board is here for.
And I understand
So-
that completely, but you are altering the property lines.
Well, that takes me to my next question, which was for the applicant, was the gentleman here has indicated that a portion of the property he believes may be within your plan, that's your part of your application. Is that accurate or not? Can you
The property that's-
delineate for sure, or is there any taking of any property
There's
or
no,
property rights, easement rights of any kind that's being taken from these folks here that are part of your application or
No.
not?
no, we're only working on property that we own. And we're respecting the easements that are deeded to the Kerchesky. So we're not
The
doing any.
easement is not a part of the little slivers that we're,
Okay, so basically anything that they may be concerned about as far as being included in any survey or drawing, that's not part of the parcels that are part of this application. And if they're showing anywhere in any existing things, that would be more for informational purposes of a larger scope of the general area, as opposed to it's
Well,
not part of your application.
This
Showing adjacent properties. I want to get it clarified from you folks. Yeah.
to the councilman's point, the easement is still on the burden's still on Greenvest and that's not changing.
Okay.
To your point of it running with the land. You're right, it would, if we sold it, it would go to the new owner, but that's not.
But there,
What's happening
can I say something?
Microphone.
What they're trying to do is take away our last 150 feet of access from the 1800s to Hoffman Road. They're stopping us. That the deeded access was like that. And it's been in fact since the 1800s. Now they want to change it and go across the back of a couple of lots and then go up that way, which denies us access to our property.
Okay, but I think what the point is, and I think Mr. Weiner said it very, very articulately, is we're looking at the application here.
Right.
And with regard to the two separate parcels that they're deeding over, and is your concern part of those two parcels that they're deeding over?
Correct.
May I say something? Please? Let me just add a little color here. My understanding from Dan Kish, who's part of this subdivision application and who's also gaining property from this subdivision, was that as long as they allowed him to utilize his driveway and his property to cut through the back part of the subdivision, they wouldn't challenge him that part of his barn was on their property. So they are doing quid pro quo on some of this, and it includes some of the subdivisions which are part of this application. That's how they're skirting the ability to get past the last 10 feet on the piece at 81 Hoffman Road. That's what I was told.
Anyone have anything to add? Is there anyone else that wants to be heard on this?
That's enough.
Thank you.
Okay, and as I understand, what the applicant is requesting is a waiver to subsection G.
Yes.
Okay. Does anyone want to make a motion?
I would make a motion to approve.
Second?
Is there a second? And any discussion?
I guess what I'm hearing is that their issue is not directly affected by this application before us. I'd ask the engineer, do we need to investigate this further, or that is totally a separate issue? It's totally a separate issue that they're raising.
Well, Mr. Chairman, I'll start with that. What they presented doesn't propose any changes to the existing easements that I see, unless I'm missing something. Can you just testify to that?
Yes, the easements were surveyed per the deeds and are shown on the maps. We're not proposing any changes to those easements.
So this does not affect any access that they would have to the road, to Hoffman Road that they mentioned. It does not affect their access. Is that correct?
We're not doing anything. The access is there. I'm not sure when he says we're talking to someone else about changing it, that's not discussion with me. I don't know if that's discussions with 81 Hoffman Road, because our easement on lot 6.02 ends, and as shown on the map, there's another easement on lot 6.05, I believe. So
You mean 6.06?
6.06, and then 6.05.
Right.
So
These slivers are not a part
the
of
the
the
road
easement area.
the roadway is there's an existing roadway that runs on that 10-foot easement through 6.06, and then 6.05 is basically someone's lawn. So the road was there.
They're not going to suddenly have to go around two properties in order to access the road.
Yeah, I'm not sure what that references to.
So Mr. Chairman, the two homeowners,
How
they're
getting in and out, please? How are they getting
Along our frontage of our property.
Mr. Chairman, the two homeowners up front on lot 605 and 602, they both signed the application. The easement, the access easement is a filed easement through the one property where the homeowner is. That appears to be unchanged.
Correct. It's on the other side. It's on the westerly side of that property. It's
So
nothing to do with the easement area.
both those homeowners signed this application, so for this to move forward, I don't see any changes to what's there. As far as if the existing access to Mr. Kerchesky's property has trees in it or something like that, is there something in that easement that indicates who addresses that? If a tree falls down across his access easement, is that his responsibility? Is that your responsibility?
It's
Maintenance is not
You're not on
required in
record.
the easement. Just access has to be provided, but not maintenance of the easement.
So the maintenance would be up to the easement owner.
Correct.
You know, if they're not changing it, what's on the plan?
Please come up and speak before.
Chris Krachewski. I'll be happy to produce the deeds which clearly state the conditions of the deals. I've looked at all the deeds back to the 1800s. It says everything on that side of the tracks is this property owner's responsibility to maintain. It's our responsibility on the south side of the tracks. I can produce those deeds. I'm happy to produce them.
Okay. We don't agree with that, but be that as it may, if that's true, then that's true. But that has nothing to do with the application.
If I may, Mr. Vanzora said it earlier, and the way I'm seeing this is any issues about burdens and benefits of easements are not being altered by this application. If there are other possible conflicts or disputes related to those issues as to existing easements and burdens and benefits of them and who's responsible for what, that doesn't seem to be part of this application, and therefore myself as a member of the board, I have to look at the application that's presented to me, not at things that are tangential at best or unrelated as to these burdens or issues about burdens and benefits and who's responsible for what. It doesn't appear that any of those responsibilities, obligations under the existing easements are being altered by the application. The landowner of where the easement is on is still going to carry the burdens, and the other folks who need access are still going to get the benefits. And correct me if I'm wrong, I'll ask the applicant, is that not being changed? Is that correct?
That is correct. That's not being changed.
Chairman, Mr. Weiner brings up an excellent point. I mean, we got a couple of lawyers on this board, but, their rights, Mr. Kaczewski's rights as they exist today, if the easement is being blocked, I mean, there's another forum for him to be at through the courts, to open that easement up for his access. This is only a lot line adjustment to shift the lot lines. It's not changing the easement. I agree with Mr. Weiner on that. And this is not the forum for that. If the easement is being blocked or this applicant's in violation of that easement, then there is another court to hear that.
Yep.
As you know.
Okay. Any other comments? Okay.
I have a motion and a second. Mr. Rothman,
Yes.
Ms. Brodsky,
Yes.
Mr. Patel,
Yes.
Mr. Slavacek,
Yes.
Mr. Weiner,
Yes.
Councilman Van Zora,
Yes.
Chairman Gaffrey.
Yes.
Thank you very much.
Thank you. Thank you. Yeah. Okay, next on the agenda, we do have a memorialization, and that's for the PB 125022 Federal Business Centers, Inc. Is there a motion to accept?
So moved.
That would be to accept the memorialization.
Correct.
You vote yes if you agree with the memorialization as opposed to.
Okay.
Is there a second?
Second with a quick question clarification. The motion we are making to deny mentions both safety and also that the applicant themselves were not sure whether they had one client or two clients. So it was inappropriate to be, even without knowing who was even going to be there and the level of traffic and the safety concerns that would be raised, that it would even be known to be able to honestly vote on. So if both, I just want to make sure it's both safety and a lack of mentioning one client or two and who they were.
Well, I believe you brought those things up at the meeting. So they're on the record. They're not specifically mentioned in the memorialization.
Do we need that in the memorialization, or is it just based on what was said at the meeting?
I don't think there needs to be an amendment. I think the
Okay.
memorialization accurately reflects the board's decision. Regarding it.
Okay, thank you.
Any other discussion? Nope. Okay, those.
Mr. Rothman,
Yes.
Ms. Brodsky,
Yes.
Mr. Patel,
Yes.
Mr. Slavacek,
Yes.
Councilman Van Zora,
Yes.
Chairman Gaffrey.
Yes. Okay, next is the public portion. Is there any member of the public that wish to be heard tonight on any topic? Hearing none, is there a motion to close the public portion?
So move.
A second. Okay, all in favor?
Aye.
Opposed? Abstain? Okay, we're closing the public portion. Are there any discussion items tonight?
Yes, one comment. I want to wish everyone here and the people in the public a Merry Christmas, a Happy Hanukkah, and also a Happy New Year.
Anything else?
Concur.
Any correspondence? Or none? Okay, move to adjourn.
Second.
Okay, all right.